Hello, my name is Cliff Marchek. I'm the Coordinator of Community Service at the William S. Boyd School of Law. Welcome to our continuing education on guardianship. This section will be on termination of a guardianship. There are several grounds upon which a guardianship can be terminated. First would be the death of the ward. Second would be the death of the guardian. Third, if the ward was to move out of state, the guardianship would need to be transferred to another state. Fourth, if the ward was a minor and turns 18, graduates from high school, or 19, the guardianship would also come to an end. At any time during the guardianship of a minor, if the ward, the guardians, and the parents agree, the guardianship can be terminated and the parents can be restored to care and custody of the minor child through what's called a stipulation and order. And we have that form for you at the Self-Help Center. Other grounds upon which the guardianship can be terminated is if the court removes the guardian. If the guardian becomes disqualified, incompetent, incapable, or unsuitable in performing any of his duties, the court will remove the guardian. Also, if the guardian mismanages the estate of the ward or fails to perform any duty required by law or court order, or it's in the ward's best interest to appoint another, the court can terminate the guardianship. The guardianship will also be terminated if the ward recovers mentally or physically and no longer needs a guardian. For example, if a ward was involved in a terrible automobile accident and was disabled or in a coma in a hospital, a guardianship would need to be established. However, if the ward recovered and came out of the coma and fully recovered from his or her injuries, the guardianship could be terminated. Now, with minor children, parents can always move to terminate the guardianship because in Nevada law, there is a strong parental preference. Parents can lose custody of their children to a guardianship. However, unless a parent consents to the guardianship or the parents are deemed unfit, parents will have custody of their children. This is called the parental preference. However, if the parents consented to the guardianship and the parents now want to get their children back, the court will look to see if they are fit at the time of hearing. The burden of proof will be on the guardian in that circumstance to prove that the parents are unfit. However, if the parents did not consent to the guardianship initially, then the burden is on them to prove that they are fit and should have their children. The Self-Help Center has this form available for parents to terminate guardianships. As you can see from this section and other sections relating to guardianship, guardianships can come to an end under various circumstances. We have listed and described those circumstances for you here. The Self-Help Center has forms available, and I encourage you to attend the Guardianship Community Service class sponsored by the William S. Boyd School of Law and Legal Aid Center of Southern Nevada for more information. Thank you.